Hello again, and welcome to our monthly get-together called Law and Society. It's where legal and social issues come together. Andrew Stevenson, attorney at law, a defender, criminal defense attorney.
Correct.
Right?
Yes.
And Andrew's been doing this series now, and we've covered a lot of what he calls his top 10 things that can get you thrown in jail.
Correct. We're kind of moving on to different phases of the law today.
This is fun. We're going to talk about plea bargains, pleas, what makes a deal good, and shed some light on the legal system, Andrew, and find out just how much plea dealing really does go on.
It goes on a lot.
So let's start with, what is a plea?
Very simply, a plea is when a person appears before a judge, sometimes with an attorney, sometimes without. They usually appear without at arraignment, which is your first appearance in court. And you may show up in court, and a judge may say, you have three pleas you can enter. You can enter not guilty, you can enter guilty, or you can enter no contest. I always recommend that for anything above a speeding ticket that you plead not guilty.
In the arraignment, the initial stage.
Arraignment. But some people choose otherwise. If you appear with an attorney and you plead guilty, usually it's because there's been a plea deal that's been worked out, an agreed proposed sentence that would be given to you in exchange for a plea of guilty. When you enter a plea of guilty, you have to acknowledge that you are guilty of the charge.
Okay, so you allocute to it.
Yes, you allocute. You give up your rights to a trial. You understand you had a long list of rights, which include the right to a trial, right to confront witnesses, the right to subpoena people, the right to an attorney, and the right not to have to testify, and the right to make the state prove your guilt beyond a reasonable doubt. And during the plea deal, the judge will go through all of this with you, and they will also then inform you that although the prosecution can make a recommendation to the court, that the court is not bound by this.
That's right. Even though the prosecutor cuts the deal, makes an offer and there's a plea deal, the judge can reject that if they don't think it's serving justice.
Or they can undercut it.
Okay. Oh, they can go the other way,
They
too.
can. Rarely do they undercut.
We had recently a case, and again, outside of your area of jurisdiction or whatever, but the Jussie Smollett case in Chicago, where all these charges were just magically dropped.
Right.
And there's a lot of people upset about that because they don't feel like justice was served.
Right. What leads to a plea deal or how a plea deal is reached, we'll kind of address a little bit in the back half of the show.
Okay.
But the thing that's most people are shocked is how prevalent plea deals are.
Yeah.
Anywhere from 97 to 99% of all cases are resolved with a plea.
That's amazing to me.
It's really amazing when you think that during the plea deal, the judge will spend up to about 3 minutes going over all of the constitutional rights that a person is giving up when they enter a plea. And the whole focal point, or the whole premise, or fulcrum of the criminal justice system is constitutional rights. Your right to a trial.
Can I ask you,
Yes.
guilty and not guilty seem pretty they're straightforward.
What's no contest?
Yeah, that one has always confused me.
No contest, at one point, some people think it's a legal loophole. It's not. What no contest is it has a very particular purpose. And what it is that when you plead no contest, your plea cannot be used against you at a later date in court. What that means particularly is civil liability. So if you are in a fender bender and you get charged with a shared clear distance, you didn't stop in time and you rear-ended somebody's car, and you plead guilty, if they sue you in civil court, they can use your admission against you, meaning that the only issue in the civil court would be damages.
Yeah.
They wouldn't have to prove that you were at fault. If you plead no contest, then the issue of liability still remains. So about the only place that you see a no contest plea is when there is some kind of potential civil liability attached,
Gotcha.
car accidents or someone's injured.
Gotcha. Wow.
Yeah, and so it is not. Most people who plead no contest, 99% of them, 99.9%, are found guilty by the judge. It's an admission of the facts. You're saying, yeah, what the state is alleging is true, but I'm not saying I'm guilty, but I'm saying the facts are okay.
Right.
So that's essentially what it is.
Gotcha. So it's akin to a guilty plea, but you're not admitting the guilt.
And it can't be used against you later in court.
Right. So back to 98, 99%. I mean, plea bargains every single day.
Every single day. That's 99% of what attorneys deal with is plea bargains. Now, the interesting part is that in the event let's say tomorrow or Monday, I guess today is Friday, every defendant in Fairfield County demanded a jury trial, the system would come to a screeching halt.
There's just not enough resources.
There are not enough resources. For example, if there are 750 felonies a year, and that's been the average in Fairfield County for a couple of years now, we only have 50 weeks a year that we can do stuff. You got to take out Christmas and a few others. That's 15 cases a week that we would have to get through. We have 2 felony judges. That would be 8 trials per judge per week. And the average felony case takes a minimum of 2 and a maximum of 10. There are simply not the resources.
Then we take the constitutional
speedy trial which
issue.
Means that on a felony, if you're in jail and you don't waive your speedy trial, they'd have to do these within 90 days. We got 200 people sitting in the Fairfield County jail waiting for trial.
Wow. Yeah.
So what would happen essentially is that the first 85, 90% of all cases would have to be dismissed because of speedy trial rights. And that would happen anywhere. And
that's any county, anywhere,
any county
across
the state. If tomorrow every defendant in this country said they want a trial, 90 to 95% would be released and the charges would be dismissed.
But everybody would have to do it all at once.
Everyone had to do it all at once. So why doesn't this happen?
Yeah, exactly.
What prevents this? It's the same. Think of the Wild West, where you had the guy who was surrounded by the gunslinger who had a gun. And he was surrounded by 5 unarmed guys, and they all said, "Let's charge him." And he says, "Well, yeah, you can charge me, and you can come at me, and eventually you all get me, but I'm going to get the first 2. Who's going to go first?"
Yeah.
So the first 2 people who were demanded trial would probably, if they were unsuccessful, receive maximum sentences from the court, and they would, in essence, get hammered, and that's why very few people do it. The other issue is that each attorney has to do what's best for their client.
Precisely.
Individually. And not everyone is going to be in their best interest to go to trial.
You're not getting together with all the other trial lawyers on a certain day and saying, let's all, there's no union
April
for this.
1st, let's go. No,
right.
It's not going to happen.
You have to decide for your individual client on each individual case what is right for them.
Correct.
And then, of course, there's the cost factor of if you cannot afford an attorney, one will be appointed for you. We'd go broke just on that.
Majority of cases in this county and across the country are handled on a court-appointed basis. About 80% of all criminal cases are represented by a court-appointed or public defender.
All right. So deals are not only an economic necessity, a reality. It's kind of our fact of life. So why do we resolve? Let's talk about the deals.
Yeah, one of the things that's changed a little bit prior to 2010, 2008. We had limited discovery. Discovery is the information that the prosecutor has to share with you. The police investigate the crimes. They write police reports. There's tests done on forensic evidence. And prior to about 2008, 2006, they didn't have to turn much of this over. And so particularly in the old, what I call the old days, the 70s, the 80s, even the 90s when I started, we would get a list of witnesses and any statement that our client made, and that was about it. We didn't have access to a lot of the evidence.
So you didn't know what the witnesses were going to testify to? We
didn't know the basis of the state's case sometimes. And so what happened was is that it made assessing your case very difficult, and you would rely only on what your client would say. Conversely, the state would only rely on what the police told them. And there was miscommunication, and so both people overemphasized the strength of their case. Now, with open discovery, we have a better ability to see what all the facts are and what the likely outcome of a trial is going to be. The other reason that there are so many deals is juries are uncertain. You don't know what a jury's going to do. The prosecution doesn't know. The defense doesn't know. We can project. But ultimately, because we don't know, there's uncertainty. And as human beings, we will always choose certainty over uncertainty. And a deal provides that certainty.
It's that you can take your chances with the jury or
you can know exactly here's the known outcome. The other thing is that a lot of times the max sentence that individuals are facing is so high. Prosecutors tend to overcharge. They tend to add many charges that they can. For example, why charge someone with simple murder when you can charge them with murder and aggravated murder?
Right.
Even if you don't have much of an aggravated murder case, you can always say, well, you never know. The jury may not like you and convict you of aggravated murder. And now you're facing life without parole.
And you've got one more that's listed, and this one just got me fascinated. Something called the trial tax.
The trial tax is a very real thing. Judges will never admit it publicly or on the record, but we all know that it is. Essentially what it is if you think about it, if a person commits a crime and they were to plead guilty to that crime, why should the sentence be any different just because you plead guilty versus you go to trial and are found guilty?
Right.
Well, the reason is because if everyone exercised their right to a trial, the judges are never going to get anything done. They're not going to be able to handle this much casework. So what tends to happen, once again, judges won't admit this, but you tend to get a larger, more significant penalty if you go to trial and lose.
The old, he's going to throw the book at you.
Yes. Yeah. Versus if you were to take a deal. So the trial tax is real. It exists, and that's kind of what it is. And then I guess the last reason is simply, as we've alluded to, a lack of resources.
Yeah, exactly. It's a matter of we couldn't handle it. It would come to a complete stop. Anarchy would rule.
Anarchy would rule. Yes.
All right. So let's. We got a couple minutes left. Let's go through the process. How does a plea bargain work? How do you do this?
Basically, there are a couple built-in stages, either a pretrial or what's called a settlement conference, at which time the defense attorney and the prosecutor negotiate. They talk. Every attorney has their own style of negotiation. And there are generally three factors that are negotiated, three key things that people negotiate. The first of which is, what is the actual charge a person will plead guilty to?
Sure.
The second of which is the time. Is there any jail time, prison time? If so, how much? And then the third thing are usually typical, what I call other issues or terms of probation. Do they have to do counseling? How much is restitution? Sometimes it's a stay-away order. Sometimes they can never go back to Walmart. Things along those lines.
Does it sometimes border between felony and misdemeanor?
It does. There are some pretty standard things. Most people are put on a term of probation. It can be either reporting or non-reporting. If it is non-reporting, it's a go and sin no more. As long as you don't get in trouble for a period of 2 years, then whatever jail time is suspended or placed over your head cannot be imposed unless you do. If it's reporting, you have a probation officer you have to see. Usually with felony, it's reporting. Usually with misdemeanor, it's non-reporting.
Okay. All right, we're going to take a break. You're listening to Law and Society. It's where legal and social issues come together. Great topic today with Andrew Stevenson. It's pleas, plea bargaining. And in our second half, we're going to talk about what makes a deal good. And probably my favorite part, and Andrew has sworn me to not look ahead, but he's got a great story to tell us in the next segment as well.